Welcome back to Hannity and Colmes. In the beginning of the Duke lacrosse rape investigation, many groups and even some journalists were quick to blame the Duke lacrosse players. But as the investigation has unfolded in the courtroom and in the media, many who once supported the accuser, including Washington Post columnist Ruth Marcus and even some writers at BlackAmericaWeb.com, are now doubting her story. For more on the investigation, we continue with Fox's Megan Kendall, and now joining us, defense attorney John T. Floyd. Mr. Floyd, I contend the reason there may be a sea change in the way this is viewed is because all the information we're getting is from the defense. The prosecutor, although quite verbal early on, has remained quiet. It is being spun one way. We're getting from those 1,300 and then 500-page documents what the defense wants us to know. So people are coming up with views based on what's in the media, which is basically one-sided.
Well, I think there is some truth to that, Alan. However, the prosecutor got an early start out in this case and gave over 40, 50 interviews.
It was months ago. Hasn't spoken since.
Months ago it was. He started the public attention to this case, and I think the defense has done an admirable job of litigating their case inside the courtroom. Much of the information that we're seeing in the press is coming from motions that were filed before the court, and they are using the media to get their point across as well.
Are they litigating this outside the courtroom, or isn't the defense playing this game of let's see how we can sway public opinion, let's see how we could possibly sway a potential jury? Litigating in the courtroom is something I'd like to actually see, so everybody, all sides, get their day in court, and there are some who don't want that to happen, it seems.
Well, I think that they are using the press to their advantage, as they should be. Like I said, Alan, the prosecutor begun this process in the press. He came out with a lot of allegations that were simply were not supported by the facts as we know them now.
We don't know all the facts.
And I think the defense needed to respond to those allegations. Otherwise, the prosecutor would have prejudiced this case before it made it to a jury with hearing nothing from the defense.
It's interesting,
so I think they've
Megan,
done what they needed to do in this case.
You know, those who wanted to support the defense, and of course John is the defense attorney, they had to respond. Well, the prosecutor, whenever he speaks, he is raked over the coals for speaking. He writes an email to a magazine. He's raked over the coals for a, quote, angry tone in an email. It seems no matter what he does, if he speaks, it's no good. If he doesn't speak, it's no good.
Well, it depends on how he goes about speaking. You know, it was probably not appropriate for him to be making all of those out-of-court statements at the beginning of this case, and it's definitely not appropriate for him to do it now. The thing that he can do, Alan, I've been saying this all along, is he can respond in a written motion form, or written memorandum, to the motions that have been filed. That's perfectly appropriate, and it will set out his case, and it's not required, but it would be good for him because he's up against these motions. I don't know why he is not doing that.
Megan, this case
Megan is 100% correct there.
Guys, it's Rich Lowry. Megan, this case isn't scheduled to go to trial until the spring of 2007. And it just seems if there's ever a justification for the cliche, justice delayed is justice denied, this would be it. Isn't there a good case for expediting this thing? And what do you think the chances of that happening are?
I don't think the chances are good because the speedy trial laws down in North Carolina are not what you think they are. And so this is, I'm told by North Carolina lawyers, that decision is largely in Mike Nifong's hands and not so much in the hands of the defense, who would normally push for a very quick and speedy trial. You are right. I mean, these boys have already suffered a good deal of prejudice. Two of them have been kicked out of school. One of them, Dave Evans, lost his job with J.P. Morgan, a very good job that he no longer has as a result of these charges. But, that's the way the legal system works. Unfortunately, once you've been accused of a crime, people start to look at you a little bit differently, and that's one of the reasons why the defense has been so aggressive in getting out there to try to clear these guys' names down.
I think that's also be another reason, John, for a DA not going out there so publicly and effectively what I'd call smearing these guys, basically, because I think this case is extraordinarily weak. But if you're going to have that smear out on them for a year or so, it's terribly unfair.
Yeah, you're absolutely correct. Not only is it unfair, it's an unwise approach for the prosecutor to take so early in the case when apparently he made a lot of these statements before he even had the evidence in his own hands. I think that he served himself to severe disadvantage by making all these public statements early on. And I agree with you. A speedy trial should be had in this case. If for no other reason, this particular case has put these young men in a nationwide fishbowl under heavy scrutiny.
Megan, very quickly, I'm going to ask you an extremely speculative question, which you might not want to answer, but can you imagine what would be the sort of evidence that Nifong has that makes this case so much stronger than it appears?
No.
No? John?
He can't have anything.
Like that.
if he has anything, it should have been turned over to the defense. I've seen people on this very show,